Welcome to the Only Male Cruise Show, the podcast. I am the only Male Cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. Welcome to the Only Male Cruise Show, the podcast. I am the only Male Cruise. Hey, y'all. Thanks for pulling up. I appreciate y'all. You know I do. All right. So, as the description says, today's episode, every man for himself. Y'all, listen. It's heating up. It's heating up. And Lord have mercy, we need a Jennifer Bongine. Let me shout out whoever's in the chat. Kitty Queen, thanks for pulling up. Appreciate you so much. All right, y'all. So as I indicated, and most of y'all are probably aware of it, and that's all good in the neighborhood. But Milton June Brown has put in a motion. They got a motion submitted. And shout out to In Living Color TV, Carla McWilliams. Thanks, y'all. Okay, so he's put a motion in. And like I said in the description, everybody they're out for themselves. And, you know, it's reasonable. That's understandable. But they got Kels on a tight rope. You heard what I said. And if you've listened to anybody else that's covered this motion from June Brown and them, y'all know exactly what I'm talking about. So really, to be all the way honest with you, we're just going to get right into it. Let's see here. Hold on just a minute, y'all. Sometimes StreamYard be giving me problems. Okay. All right. So y'all are probably already familiar with the motion. And those of you who have not, then hold on tight. So right now, to my understanding, June Brown, to my knowledge, I think it's just only one count 6 that he's being charged with. I could be wrong. So if y'all know in the comments, definitely, drop the details, the accuracy in the chat. But he's count 6 of the indictment charges Mr. Brown with receiving pornography in violation of USC 18, blah, blah, blah. Specifically, the indictment alleges that from 2001 to 2007, June conspired with Kels and Darrell, individual A, individual B, to receive videos 2, 3, and 4. Okay. And it says here, count 5 alleges that Kels employed Mr. Brown from approximately 1997 to approximately 2019. And it says count 6 is the only count under which June Brown is charged. So, okay, so let's just get into right into the meat and potatoes of this thing. So one request that June's attorney has asked for is this court should preclude the government from eliciting testimony regarding certain other crimes, wrongs, or acts by Mr. Brown. This court should bar the government from eliciting testimony from minors 4 and 6 regarding the times that Mr. Brown booked hotel rooms or otherwise made travel arrangements for them. So when you look at what they're trying to limit Brown to be charged on, it's not a whole picture. It's just like, okay, on one day, Kels just happened to be in a room with one of these girls. They don't lead the path. They don't draw, from point A to point B, how it all turned out, how it happened. So I wasn't there is pretty much what they're saying. They don't want minors 4 and 6 to even be able to testify about any hotel rooms that June Brown booked, or any other travel arrangements that were made for them. Shout out to Baby Shay in the chat. I appreciate y'all so much. Y'all don't even know it. One of these days, I'm going to do a Cash App giveaway just to show y'all some love and appreciation. Hit the like button, share, subscribe if you haven't already. All right, so the government may seek to elicit testimony by minor 4 and minor 6 under federal rules of evidence. Specifically, the government may seek to admit statements by witnesses, including minor 4, minor 6, that Mr. Brown reserved hotel rooms for the minors on behalf of co-defendant Kales. Testifying before a grand jury, this is what minor 4 stated. I talked about a time when I went with my friend to pick up a hotel key from Abe, who was at the front desk of Rob's record studio, Tracks. Before that happened, I had a conversation with Rob's assistant, Milton June Brown. June was the one who told me that Rob wanted me to get a hotel room and wait there for Rob. June wanted me to reserve the hotel room myself. I told him that I couldn't do that because I was only 16 years old. Okay. And then appearing before the same grand jury, minor 6 testified. When we traveled before I was over the age of 18, Rob had employees who would help arrange my flights and who would meet me at the hotels to give me keys to the hotel rooms. Often, the people who helped with arranging flights and hotels were June Brown and June Bug. I believe that June and Junebug knew that I was under the age of 18 because I could not get my own hotel rooms, which y'all already know. Some of these hotels, they want a credit card so they can pre-bill that card for amenities in case you know what I'm saying, go in there and clean out that little refrigerator with the alcoholic beverages up and through there. So we don't know that that's why. Shout out to Peace and Love. Thanks for pulling up, girl. But we don't know why that's why you couldn't get yourself a nice little hotel room. So she says, and they had to do it for me. June met me at a hotel and gave me a room key when I was still under the age of 18 at least 10 times. So Brown's attorney goes on to say the probative values of those statements, if any, would presumably be to demonstrate knowledge under Rule 404, insofar as the statements would suggest that Brown knew that the individuals were minors because they could not reserve hotel rooms on their own and needed June to do so for them. These statements should be barred under Rules 802 and 404, and I do have some 404 details for you in a minute. The attorneys go on to say, generally, evidence of others' acts is inadmissible to prove a person's character in order to show that a particular occasion the person acted in accordance with character. This is, however, an exception to the general rule where the evidence is admitted to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. In determining whether bad acts evidence could be properly admitted, under Rule 404, courts previously have considered whether the evidence establishes blah, 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 blah. Let me get to you and let y'all know what 404 is. I made this little note. Okay, so Rule 404 basically says prosecutors love to prove that a defendant has had a prior criminal record because it effectively negates the presumption of innocence. And empirical studies show that jurors are willing to give an accused the benefit of the presumption of innocence only if it's like the accused's first offense. And so this is why they're saying we don't want minors 4 and 6 to be questioned because under Rule 404, it's going to make the jury feel like Brown is already guilty, and it's not going to really give him the opportunity to say he's innocent and didn't know what he was doing. That's kind of like the layman's term of the definition. Okay, so alternately, these prior acts would presumably be offered to show an increased likelihood that Mr. Brown should have known that the tapes at issue in Count 6 involved a minor. So hold on just a minute here. Okay, the alleged hotel room reservations and travel arrangements made by Mr. Brown are irrelevant to the allegations in count 6. First, hotel reservations and travel arrangements for minors 4 and 6 are irrelevant to the charge that Brown is facing and therefore should be inadmissible. As it concerns Brown, this case involves only one count, and, and that's count 6, and only one minor, minor 1. In that count, Mr. Brown is accused of receiving child pornography depicting one minor, making travel arrangements, and reserving hotel rooms on behalf of an employer are actions that are not all that similar to receiving child pornography. Additionally, these prior acts occurred years before the conduct alleged in count 6. Simply put, Mr. Brown's knowledge of other victims' minority statuses is not relevant to whether Mr. Brown knew the minority or the age of the individual depicted in the videotapes or not. So when they say here that these prior acts occurred years before the conduct alleged, they appeared years. It happened years before. So then why is it even a count? Why are we even going to court for this? Okay, how can you argue that this happened a long time ago? So I thought it was important to really just get law here and seek justice here. So if it happened a long time ago, we need everybody in an orange jumpsuit then, okay? So you can't make that argument that it happened a long time ago, so don't hold Brown accountable. I'm sorry. That ain't right. And it says here the other crimes, wrongs, or acts here are improper propensity of evidence. Let's see. Second, Mr. Brown is charged only in count 6, which involves minor one's age alone. The prior bad acts evidence discussed here would, even if relevant, be improper propensity evidence. The value of these statements to the government may be that since Mr. Brown allegedly aided Kell's exploitation of other minors or knew that Kells had relations with other minors, the jury might be more inclined to believe that Mr. Brown would have been more likely to have aided Kells in obtaining the videotapes. Alternatively, these prior acts would presumably be offered to show an increased likelihood that Brown should have known that the tapes had some minors on there. Okay, let me scroll down here, y'all. Hold on. All right, so indeed, the statements necessarily involve propensity inferences of the worst kind. So first, they depend on an inference that when allegedly working with Kells to retrieve the tapes, Mr. Brown acted in accordance with his prior unrelated conduct. Further, they also depend on 3 additional, even more troubling inferences unrelated to Brown's own character. So essentially what they're saying right here is Brown was just doing his job, and that's why we don't want you guys to have minors 4 and 5 testify about Brown, because if you do, then it's going to make his character look bad. And the inferences that are unrelated to Brown's own character are the following: that Kells, when producing the tapes, acted in accordance with his prior conduct, given that Kell's prior conduct, the person depicted on the tape, was likely a minor. So essentially they're saying that Brown was hip to all this as it was going on. Also, that Kells would have been more likely to ask Mr. Brown to retrieve the videotapes because Kells had employed Mr. Brown to facilitate his prior unrelated conduct involving minors. Thus, the statements would violate the principle articulated in this particular rule or law called Gomez. In sum, the government should be barred from eliciting such testimony. First, the other acts evidence constitutes inadmissible hearsay. Second, the other acts are too dissimilar and distant in time to be relevant to the allegations in count 6. Third, the other acts evidence constitute impermissible propensity evidence. And propensity evidence is defined as evidence that is extremely prejudicial to defendants because it creates an easy, acceptable belief in the prosecution's case. So, If 4 and 6 testify, it's going to be hard for June Brown to say, I didn't know nothing. It wasn't me. I went hip to the square. I just, all I did was book a hotel room. All right. Brown's attorney is also asking, this court should bar the government from eliciting testimony from individuals D and B regarding Brown's role in arranging an abortion for one or more of Kell's alleged partners. And let me, the other night when we was on here, y'all, I was I think I was saying Asante McGee was individual D, but shout out to Saka Jams, who let me know on Twitter that individual D is actually Lisa Van Allen. So I appreciate you hipping me up to it. So um, so essentially it's saying the government may seek to elicit testimony from individual D regarding the role Mr. Brown may have played in her abortion. Specifically, the government may elicit testimony from individual D that Kelly paid for the abortion and that Mr. Brown, acting as Kell's assistant, made the abortion appointment, drove individual D to the appointment, and posed as individual D's uncle when they filled out the paperwork for the procedure. Now, y'all let me know in the chat, wasn't individual D already of age? So why would why would she even need a family member? Unless they said, well, let's, put in, give us the name of someone who, we can call in the event of an emergency. Let me check the comments. Tiffany only, please. The more and more I hear these damn motions, everyone, witnesses, 2 others charged are receiving favor in this case. But Mr. Kelly, you better ask somebody. Additionally, the government may seek to elicit speculative testimony from individual D that Mr. Brown and others arranged abortions for minors on Kell's behalf and that Mr. Brown and others had asked him about abortion laws. Asked who? And who's y'all? Do y'all know, anybody in here know who individual B is? If you do, drop it in the chat. Let's put some faces to these names. Hold on. Peace Love said, let me see. Uncle cannot consent unless they have custody of a minor. Right. And the thing too is, I don't even think that she was a minor at the time. That's the biggest thing. Because this is why I believe we discussed it, that she wasn't charged to begin with because she was already of age. But anyway, so then if she just put him down as an emergency contact, then that's hit or miss. All right. This court should bar the government from introducing these prior acts. As with motion in limine number 2A, the acts here, Brown's alleged conduct in arranging abortions, are irrelevant. First, individual D was either 19 or 20 years old at the time and was therefore not a minor. So does it really matter if she put June down there as a... Okay, so if she put Brown down there as a uncle, so what? And if she's 19 or 20 years old, if she did ask Kells, what did he know about abortion laws or whatever, she was totally of age to make that happen. So that's just a conversation. All right. Second, individual D's minority status is not an issue in this case as it concerns Mr. Brown. Third, there is no indication that minor 1 is one of the minors who were rumored to have received an abortion arranged by Mr. Brown. Fourth, these abortion allegations are not similar or close enough in time to be relevant to the allegations in count 6. So I feel like if Brown can get count 6 and get all this stuff marked up off of there, then I presume Bonjean's motion should be very similar to this. Further, should this court determine that the testimony is relevant, the court should exclude it as unduly prejudicial under the rule evidence of 403. It says, Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusing the jury, or wasting time. Evidence is unduly prejudicial if it creates a genuine risk that the emotions of the jury will be excited to irrational behavior, and the risk is disproportionate to the probative value of the offered evidence. Testimony that Mr. Brown arranged abortions for minors is obviously likely to elicit a strong negative emotional response from jurors. Additionally, because those rumored and alleged abortions involve people other than minor one, and because the ages of those people, including minors and adults, varied significantly between the ages of 16 to 20 years old, there is substantial risk that the testimony would confuse jurors. Okay. Then I think that it's the responsibility of the prosecution, since y'all bringing this case, to make sure the jury understands. Okay, so there are, like I said, it's a tightrope, and maybe y'all are afraid that that the government can't make them understand because they really don't have a case. Let's see here. All right. Accordingly, Mr. Brown moves to bar the government from eliciting such testimony. The court should preclude the government from eliciting testimony from individual B regarding Mr. Brown's role in inviting concert attendees backstage for kills. The government may seek to elicit testimony from individual B regarding the role Mr. Brown may have played in inviting minor concert attendees to meet Kells. Specifically, the government may prompt individual B to testify that Kells would identify girls ranging in age from 16 to 20 years old. Now, if Kells was at a concert and on stage, could 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 Kels really look at them girls in the audience and be like, "Oh yeah, she 15. That's what I like. Oh, she 12. I like that." I mean, that's not even feasible. So again, this is June Brown's attorney saying that the government should not be able to do this. So in all actuality, Bonjean's response to the motion that we went over the other night should damn near mirror this, because it sounds like a good argument to me. It's definitely getting June Brown. June Brown is definitely being asked to be let up off the hook, specific to count six. So Kales ought to be able to ask for the same thing. So, Mr. Brown may have played a role in inviting minor concert attendees to meet Kells. Specifically, the government may prompt individual B to testify that Kells would identify girls ranging in age from 16 to 20 years old in the audience and instruct his employees, including Mr. Brown, to invite them backstage. For the reasons discussed in Motion 2A, the court should bar the government from eliciting testimony as to Mr. Brown's role in inviting concert attendees backstage to meet Kells. So if Kells told Brown, "Look, I want to pick out some shouties about the audience," and it was a standing rule that Brown and all the rest of them were supposed to check these lying girls' IDs. If Brown and them are saying, "Well, the government shouldn't be able to ask me about that," then Kells doesn't get to say, Kels, then Kels and them can't ask, did you show an ID? Did Brown make you show an ID? Did you tell them at the time when they were pulling you out of the audience how old you were? Did they ask you how old you were? So it's leaving a lot of loopholes in there. Okay. One more of these prior acts are irrelevant to the charges in count six. There is no indictment that minor one was one of the attendees who Mr. Brown invited to meet Kelly in this way. Indeed, minor one did not meet Kells at a concert. Moreover, Mr. Brown played no role whatsoever in the introduction of minor one to Kelly. Also, there is no indication that June witnessed Kells engage in sexual activity with any of the attendees that he invited backstage. Again, this conduct is not similar enough to be relevant to the allegations in count six. Further, even if this court finds that it is relevant, it should preclude testimony as to the acts under Rule 403, and that is that it might prejudice the jury. As the abortion discussed above, the alleged conduct here would unduly prejudice and confuse the jurors. This court should bar the government from eliciting expert testimony from unqualified witnesses. Um, and hold on, I'll just read it directly. The government may seek to have law enforcement witnesses provide opinion testimony about child pornography, generally including typical offender behavior. This testimony would be based on special knowledge and expertise outside that which the average lay person possesses, so it would be inadmissible as lay testimony. Basically, they're saying they don't want, what says here, as such, before being permitted to elicit such testimony, the government should be required to qualify that witness as an expert. If the government does not seek to qualify a witness as an expert, that witness should be limited to giving fact testimony and only those opinions or inferences that are not based on specialized knowledge, such as that witness's participation in the investigation and statements made by others. And just like in the other motion that we went over the other night, where the government was saying, we don't want these pornography tapes to be played in full view of the public within the courtroom, because it's been determined that it makes the victims have pornography out there forever, and it's had a traumatic and mental impact on them, this, that, and two-thirds. So this is why they're talking about here about the opinions. It says here, if the government does seek to qualify a witness as an expert, that witness should be limited to giving fact testimony and only those opinions or inferences that are only on specialized knowledge. So they have to technically be an expert. Anyway, the government may seek to avoid the expert testimony requirements by characterizing these witnesses as summary witnesses or claiming that they are merely summarizing evidence. But merely claiming that witnesses are summary witnesses does nothing to alter the application of Rules 701 and 702. I looked that up, but I forgot what it was by the time I got down here. So, because such law enforcement witnesses' testimony would be based on knowledge about child pornography about which lay people are uninformed, that it would then trigger another rule. Let's see here. Court's important gatekeeping role merely by characterizing these witnesses as summary witnesses, particularly where, as here, Mr. Brown is making this objection well in advance. Well in advance of the testimony. Okay, this court should preclude government witnesses from providing summaries or statements from interviewed witnesses for non-testifying individuals. Now, they're claiming here something about the Sixth Amendment, that it provides a criminal defendant with the right to be confronted with the witnesses against him. To satisfy the Confrontation Clause, testimonial statements of witnesses absent from trial may be admitted only where the declarant is unavailable and only where the defendant has had a prior opportunity to cross-examine. So that makes me think that maybe somebody don't want to show up in court, but they want to have a, what do they call that? An affidavit, or maybe even a videotape. We're going to see. Hold on. Shout out to all y'all in the chat. Thank you so much. Be sure to hit the like button, share, subscribe if you haven't already. Despite the Confrontation Clause guarantee, there are some limited exceptions. Okay, as the Seventh Circuit noted, we have explained that such out-of-court statements are admissible as non-hearsay when offered to make a defendant's recorded statements intelligible for the jury, that is, for context, or when brief and essential to bridge gaps in the trial testimony that might significantly confuse or mislead jurors. Okay, anybody understand that? Be honest with me, because if you do, I'm going to ask you to tell me what it means. Somebody tell me what it means. Tiffany Only Please said, I heard Miss Bone Jean started her closing arguments today for Cosby so she can return and be focused on this case soon. Oh, I hope that's true. Shannon Lewis, shout out. Concert venues should be responsible for tickets getting into alleged underage hands. Absolutely. Absolutely. All right. I'm just trying to really get to the meat and potatoes, y'all, because y'all know I'm not no attorney. Um, let's see here. Hold on just a minute. All right. So here they're talking about applying for some confrontation clause because of testimonial, blase scoop. I'm not going to get this. This confrontation clause is a little thick for me, y'all. I'm going to be honest with you. I don't really have a full understanding of it. They do have some side examples. They've cited some examples in here. Um, but ultimately, what it does say is Mr. Brown asked this court to exclude from trial any reference to the statements or other non testifying individuals as violative of the confrontation clause. Additionally, under Rule 802, Mr. Brown asked this court to exclude any hearsay statements that are not subject to Rule 801. This court should preclude the government from making Golden Rule arguments with regard to the jury and the defendants. The Golden Rule arguments is basically them saying the prosecutor says the government may not ask the jury to put themselves in Mr. Brown's shoes and ask them to consider what they would have done if they were him. And they said that they don't want that to happen because it distracts the jurors. From focusing on the evidence. It says here a Golden Rule appeal in which the jury is asked to put itself in the defendant's position is universally recognized as improper because it encourages the jury to depart from neutrality and to decide the case on the basis of personal interest and bias rather than on evidence. Okay. Does it seem like a tightrope to y'all? Mr. Brown also respectfully requests that this court allow him to submit additional motions in limine in response to subsequent discovery productions, notice as to Rule 701, 404, or as you are 702 and 404 evidence, and the filing of witness and exhibit lists. So we know that there's going to be more motions on behalf of Brown, and it's rightly so that his attorneys should be fighting only for him because, they're only representing him. And what I found out is that June Brown's attorneys are actually coming from the Federal Defender Program. And the Federal Defender Program for the Northern District of Illinois is an independent, nonprofit community defender organization. It says they've been fighting for justice since 1965. So I guess there's a step up. What is it? A public defender? I guess these are public defenders on a federal level. Does anybody have any questions or any additional information? Because I know some other people have covered this. Let me check the chat, see what y'all saying. Shannon Lewis said, interesting. Yeah, it is interesting. But, so I wonder if there is any animosity or some fighting between Kells and June Brown, because they do both share this count. And personally, like I said, I can't wait for Bonjean to respond to the motion that we went over last night, because it's going to be interesting to see if her arguments regarding count 6, if they are the same, or if they are just immediately like, no, we want them to testify, because it would seem like they would want Jane Doe or minor 1 or 2 or 3, whatever, would want them on there. When Brown handed you the keys, what did he say? You know what I mean? Let's get that out. Did you tell Brown that you were 8 to 16? Yeah, but he said don't worry about it because Kells would never know. I mean, come on now. Why? I mean, this is how I perceive it, that it's locking Kells down where he just can't get the entirety of what actually happened, especially if Brown and others were responsible, as his motion states here, was responsible for getting the girls up out of the audience. We know Kells wasn't on the stage performing and pointing these chicks out. And he didn't wait till the concert was over and stand on the stage and say, hey, you, hey, shawty, Yeah, hey, Mama, Miss Mamas. We know he didn't do that. We know that they brought these gals back to him. So it's just, I don't know, y'all. I don't know, y'all. Now I don't know how y'all feel, but I'm happy to drop the link if anybody wants to come up and got something to say. We can chop it up. Um, Jason French, free R. Kelly. Shannon Lewis said, interesting. Tiffany, only please, what you say, if you are on the East Coast, you will try to, if you are on the East Coast, will you try to attend the sentencing? I probably won't because I presume, and for one, I'm not on the East Coast. And then for two, there might be some hiccups along the way. Even though they want to quickly move it, there's no telling how that's going to turn out. So I don't know, y'all. I don't know. But, the block is hot. June Brown and them do intend on presenting or submitting more motions as the situation presents itself. So, we're just going to stay on top of it and see what happens. I'm going to give these comments one more last go round. Let's see here. Like I said, be sure to hit the like button, share and subscribe if you haven't already. And again, I'm thanking all of y'all for pulling up. What's new? This is what's new, Carla. This is what's new, girl. Um, but the motion is to me is pretty well written. It doesn't seem, the argument seems reasonable if you're trying to defend, if you're trying to defend your client. So I feel them on that. But for the same justification that, as it relates to motion 6, if that can, if that's okay for June Brown to have that benefit of the doubt, then Kels ought to get it too. Kels ought to get it too. Let me see. All right, y'all. Well, looks like I went through all of the comments. Ain't nobody said drop the link. So if that's the case, let me see. Hold on just a minute. What you say? In Living Color, I like the way Mel said. But you already know this how it go. Annie from the Shy. Come on, Neil. You know how they go. You know how they go in Living Color TV. Yes, let me see here. Let's see. Thanks again, Mel. Yeah, Toria Williams. Thank you, girl. Hey, I was trying to find the information on the Tasha K. So you might need to hit me up on Twitter in the inbox or on IG and let me see, because I'm trying to figure out what's up with that Minnesota BOP person. I need to know, did they let her retire and then it wasn't no problem thereafter? Shout out to Doo Wop. Thanks for pulling up. Did they just let her retire quietly? Can you put your email up? Yeah, let me see. You know what I'm gonna do? Let me see. I don't think none of my mods in here got it. Um, Let me try to put it in the chat real quick. Well, you know what? I'll pin it to the I'll put it in. Hold on, let me just try it real quick. Shoot. Hold on just a minute. So how are y'all feeling though about this case coming up? Do y'all feel like how are y'all feeling? Put that in the comments. Hold on. I believe that's it. Here we go. There goes my email, Doo-Wop. Thanks for asking, girl. Let me see. Just D said, thanks for updating us. You're welcome, Just D. I appreciate y'all pulling up for the updates. Um, Patty Q said he's performing, not pointing out women. The government is crazy. Girl, ain't that the truth? Jason said, would Aaliyah be Jane Doe #1? That is such a good question. Hopefully, what's my girl's name that gave us that accurate information? Shaka Jams. Maybe she can tell us, Jason. Shaka Jams, if you pull up, let us know. Who is minor one in the Chicago case? Because we need to know this. We need some names with these identities. Yeah. Oh yeah, there goes my email, y'all. Hit me up. Um, Anxiety will be high approaching that day. Yeah, mine too. But, I just have confidence in Bone Jean. And I think she knew what she was doing when she pulled up this case. And again, she has stated before in an interview that just from the New York case, she knows that Kells, she feels very strongly, just based on the rule of law, that Kells got a jammed up trial and everything else is it's all jammed. And so I don't think she would have even went for it if she didn't think she could handle it. And hopefully hopefully she does. Because my thing is this. Okay, so we know Kells and knocks and boots. We know that. That is not what is being argued. And I did see, on YouTube earlier, somebody was saying something like, um, and DJ Tyson, which that's a bad Papa Dappa. You heard what I said? So if y'all, I'm sure y'all probably already follow him, but if you don't, make sure you check him out because he just lays it down. And I'm gonna tell you, I like when he bangs on the desk when he's making his point. But like he was drawing some comparisons. Apparently, somebody was on a YouTube channel talking about um, Kels and saying that y'all don't care about the girls and the little girls in the case. And so Tyson was making the comparison that okay, fine, but also make sure you are holding the same way you're trying to blame Kels for whatever activity he participated in. Make sure you hold the parents responsible for them facilitating that activity. And just like this with Brown, y'all saying, well, don't let the government ask for and minor one and four and six, how'd they get to the hotel? So now, because they're gonna look at me and think I'm bad, but you did what you did, whatever you did, and what we need to know, because here's where it all comes down, because what we really can tell is a lot of people misled Kels on purpose. They played Kels, and if Kels trusted you to pull some women up for him, and he told you, especially after 2008, make sure you check their IDs, man. Make sure you check their IDs. If Kels told you to do that and you didn't, then we got a problem. And that's what the jury needs to hear. And I know somebody in the comments knows this, and I think I'm reciting this information correctly, but isn't Geronda the one who, some kind of way, they made some type of settlement occurred, some type of way, and she split it with what's his name, Bubba? So we need to know all this. The jury needs to know all this. You know, especially when it comes to, were you asked how old you were? Yes. Did you show ID? Yes. Was it a false ID? Yes. The jury needs to know that. Y'all want the jury to be unbiased and make an opinion and use their brain. So give them the information to process. Doo-Wop said they're reaching for they reaching lying and everything else. Ain't that the truth? Let's see. Minor one is LaShonda Landfair. That's the conclusion we came to last week or earlier. Jennifer is working against a machine and a bunch of elite folks. Yeah, but you know what? Jennifer is a white woman, and so she's part of that elite team. Now she might be on a low totem pole because she, just due to the fact that she's a woman, but she's white, so she got access. So, but we just have to see. Let me see. Jason said LaShonda. Yep. Let's see here. They play Kels. That's facts. Let me see. Tiffany Only Please says she is really a one-woman army handling 2 high-profile cases. That is a lot. But she also strikes me as the type of lady that if you're going to work for her, you better know what the hell you're doing, and you better do what you're told. If she delegates some responsibility to you, you better be on it, or you won't be part of that firm for long. So Geronda had 3 settlements. She never had sex with Kels. Let me see here. Shannon said, "You right, Mel. I try to be right at least 2 times a day, Shannon." Yes, Doo-Wop, you're right. God is in control. And that's ultimately who we have to count on. So, and along those lines, have y'all ever been in a position where everything was just going wrong, 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 but there was a purpose in it? There was a reason for it. And I feel like that is the predicament Kels is in right now, because it's out of control that everybody derailed. Individual C, what's my man's name? Even the spokesperson that Kels had, who was speaking for Kelly, and then he went on there with Gayle King, and on the last interview he did with Gayle King, Gayle King said, "Would you leave your daughter alone with Kels?" His daughter is 20 plus years old, so that's a moot point. And he said, I would never, this and that. And then later on that day, he resigned, only to find out that he has great admiration for Michael Avenatti. So was he trying to plant seeds of destruction and distrust about Kels at that time as well? That's what I was wondering. And then there's video of him and Avenatti going out to dinner together. And the man talking about, yeah, I got high regard, a lot of respect for Avenatti, but where's Avenatti at today? And this is the same person who I believe is in the, which I did do a video on the job, but I had to put that video on private because I just had technical difficulties. But the thing that we found out about this R-Line person was the fact that in the conversations, and maybe I'll try to go over that tomorrow during the day, but R-Line was talking to a third person, and in the phone records, he's saying, well, I got to check with so and so because he's doing all the talking for Kels now, and this is and that was the black. I'm gonna come live tomorrow and do it tomorrow, so I'm not gonna try to confuse y'all right now. Look, y'all. Thanks for pulling up. Hit the like button, share, subscribe. If you haven't already, Replay Gang, leave a comment. I want to hear from you. Tiffany, I do believe so. Because, yes, y'all pull up tomorrow. I promise you I'm covered. Because the thing with that guy, the black man, his name is Daryl. And he was brought up on some charges. And actually, Tasha K interviewed the people that he had manipulated, but they brought him to court, and I've been searching and hunting, trying to find what that determination is. Did he get probation? Blase scoop. So, but I'm going to come live tomorrow and talk about it in detail. But yes, Avenatti is certainly in jail, and he actually went to that's right, Doo-Wop, he does. He worked for Greenberg. So anyway, we'll get all into it tomorrow because I don't want to mix it all up. But again, I appreciate y'all for pulling up. That's it. That is the podcast. Be sure to like, share, subscribe, Replay Gang. Leave a comment. I want to hear from you. And until next time, y'all, we will see ya when we see ya. Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe. Replay Gang, leave a comment. I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.